Welcome back to the Noble Forms tutorial series. I'm Richard Noble, the founder of Noble Forms, and I'm going to explain in this video how do we deal with the estate plan for the surviving spouse after the death of the first spouse in a joint trust plan. We've been talking about in earlier videos the administration of the trust at the death of Jane. But now we want to go back and we want to work on John's plan, John going forward. And to do that, what we do, I don't want to just change, I could go back and just open up the old, this is the Noble Forms, home screen for the married couple, John and Jane. But I don't want to use this anymore. I want to just have one just for John. So the way you can do that is to go to the three dots over here, and there's you see where it says export. I'm going to export this file, and you can save it. And I'm going to save it, I'm going to call it Married Couple Post-Death of Jane for John Andrew Jones. I'm going to call it that. So I'm going to save it. And then I'm going to create a new record here. And so I go over to create record, and you notice at the very bottom, there's an option to import JSON or CSV. That's the type of file we just saved. So I'll say okay to that. And now you can drag that file name in here, or you can search for it in your file directory. I'm just going to search for it. And this is it right here. So I'm going to open it. And I'm going to upload it. And I'm going to close this. And now it says estate of Jane Jones right here. Now, that's not what I want. I want John. Actually, my mistake. If you go, the one that's highlighted is the Jane Jones. If you go up one level here, you see it doesn't have any name at all. So if I select an app and do estate plan, and if I start answering the questions here and kind of editing the form, first I'm going to pick the attorney, John J. Olson. On client type, for now, I'm just going to leave it as married couple. Because if I do that, and then I go down and open up documents, you see there's a field here where I can pick whether it's going to be for John, Jane, or John and Jane. And if I had gone back up here and for client type picked single person, this wouldn't open. I wanted to open, and I don't really need it here because it's going to default to John because John is the first client. But if I wanted to do it for Jane, for instance, say John had died and I wanted to do it for Jane, I'd have to do it this way, pick Jane, and then go back and say single person if I wanted to do Jane, because it wouldn't know which client is widowed or not. So I'm going to pick John. Now, if I go back up and I can say this is trust to be created is a separate trust. And if I go up here and do, instead of married couple, go back up here and say, and all this is right. This is the original. This is the original trust. This is the original name, the date. This is the original name. And I'm going to go back up here. And now I'm going to change it to single person. And it still has this information here. It's just a little quirk. I just wanted to, if you don't do it the way I said it, sometimes you won't have the option to pick John or Jane. So this way, for sure, it's going to be for John. It's a separate trust. And we're going to do a restatement. It's going to be a restatement for John. This is the original date of the trust. And the name of the trust isn't going to change. It's still going to be called the John and Jane Jones Trust. Client information is all the same. Children's the same. Other important people is the same. Disinherited people, you could change it or keep it. And then you could change all this. The trust general information, it's revocable. He's not revoking an existing trust. He reserves the right to amend in Article 4.1a. Was John the sole settler of the trust being restated? No. And you can just type in Jane's name. She was a co-settler. Asset schedules we're not going to include. We are going to include special needs protection. It has not been previously amended. All these, we'd have to just answer them as according to the facts. I mean, if they had amended their joint trust before Jane died, you'd say yes and enter the dates of the amendments. Now, the trustee designations. Now, the original trustees were John and Jane while Jane was alive. But now, initial trustees for the restated trust are just going to be John, and then the successors are still the same. Now, they could change. He could make any changes he wants here, but these are the ones that were there in the joint trust, and they're still acceptable, so we'll keep them. Trustee additional information is all the same as it was before. You had to type in reasonable, didn't bring that over. Had to click accept reasonable compensation. We're going to include special trustee provisions. No specific gifts. He could put a gift in here if he wanted to. He had a gift for John. For John, you could put the gift. He had a gift. I forget what it was in the original trust, but he can put whatever he wants in now. Tangible personal property is going to go to children. You notice there's nothing in here about Jane because Jane's deceased. There's no question, is it the residue going to Jane if Jane survives, and all the language about the disclaimer, and that's not in here either. Those questions aren't asked because he's a widower now. Lifetime distributions, who are the beneficiaries? Lifetime distributions, well, maybe, I don't know, but typically if he was, I think these kids are young. I think we have them down here as in this hypothetical, I believe they were young children. Let's see, where's the children information? Oh yeah, sure, they're young, 14 years old. Yeah, so yes, during a lifetime, down here on, if the settler becomes incapacitated, is the trustee authorized to make distribution to the descendants? Yes. Standard provisions if incapacitated. Trustee final distributions. Children equally, held in trust, divide immediately, all at one age, 25, discretionary. And of course, you could change this. You could put anything you wanted in here. Now he's restating that he has the right to amend it. Beneficiary age 25. I mean, most of this came over from what was the joint trust, but it can all be changed at this point here. And now this one's new because this one this is an option. So if he could go half to his deceased wife's heirs at law if there were contingent beneficiaries, and the name of the spouse, you tried to type this in. The execution, you put the new execution date for this restated trust. Well, let's create a document and see what we get. Okay, so here's the joint trust. And this one's the restated trust. I've already run this first, so I'd call it restated. It's the restated John and Jane's trust. Say okay to that. And then let's take a look at it and see how it looks. Okay, let's look at it in single page view. Make it a little bit bigger. Go to View menu. Look at the nav pane. Put a bracket in. No matches. So all the questions were answered. Close down this. Collapse this. Take a look at the beginning of it. What do we got here? Restated revocable living trust agreement dated day of signing John Andrew Jones, the settler, and John Andrew Jones is the trustee on December 24, 2024. This is, of course, these dates wouldn't be the same. There could be a lot more time go by between them, but that's exactly what we had. On December 24, 2024, John Andrew Jones and Jane Alice Jones, husband and wife, as the settlers, and John Andrew Jones and Jane Alice Jones as co-trustees entered into a trust agreement, the original agreement. The settler desires to exercise his retained power to amend the original agreement pursuant to Article 4.1a by restating the same in its entirety as hereinafter provided by entering into an agreement, the agreement with John Andrew Jones as the settler and John Andrew Jones as the trustee. This trust agreement shall replace all previous agreements, amendments, and restatements. Name of trust. This trust shall continue to be called the John and Jane Jones Trust, dated December 24, 2024, even though it was amended and completely restated on December 29, 2024. And if you go look at the trustees, here's the trustee succession. John is the original trustee, and then Robert, then Sandra. So now it's just a restatement of, but what's important is, you're going to see here in a minute, all of the assets have come over that were in the joint trust. Remember, we went through and we did Jane's trust administration, and we created a data death spreadsheet and deleted the assets that belonged to John. Well, now let's go take a look and see how the assets play out here, and see how we have to edit the assets to make it consistent for the assets that John owns now after the death of his wife. Now let's go ahead and select another app. Let's select the Funding Fees Explanatory Material app. I want to work on the assets now. Let's take a look at the assets. Well, first we have to pick a document. So let's do spreadsheet. Now, because we clicked spreadsheet, we can see the assets down here. Let's take a look at the real estate. So this is how it was set up for the estate plan originally, when they were first doing their estate planning, and they owned everything individually. But we know it's owned by John's Trust, and it's still going to be owned by John's Trust. That's for sure. Looks like maybe everything's the same. Maybe you can edit it, put in different values at this point. Maybe there's no more mortgage. Just edit it to make it accurate for now, and go through each asset like that. Now, remember, there was I guess you don't see that we added on Jane's, when we did her date of death, there was a property over at Gerhardt that she had inherited, and it wasn't included in the original estate planning list of assets because she got it later and she never bothered to put it in. So we would want to put that asset in here as another, because remember, at her death, we had to go through, use a simple estate affidavit, and at the end of that proceeding, the property at Gerhardt was deeded by the affiant, which was John, to the trust, and it's been distributed. Now it's part of the trust. So and John's the only settler at this point. So let's go ahead and we'll add that. So I've filled in the asset information for the Gerhardt property, and that's now in John's trust. What we want to do now is go back and take a look at the spreadsheet that was created during the estate planning and look for assets that were owned by Jane, and make sure that now we've indicated that those are now owned by John. She had 2 insurance policies, but those were liquidated at her death. So this first insurance policy here from MetLife that Jane owned, that doesn't exist anymore. And also the MetLife policy that she owned for $500,000, she doesn't own anymore. So let's go take a look at the insurance policies. So the first insurance policy she owned ended in 678. This one here. So this one is that 678, that's number 24. So number 24 doesn't exist anymore. He would just have more money in one of his accounts, probably. And the second policy that she owned ended in 887. So that's this one here, number 24. So that doesn't exist anymore either. Now, she had a retirement plan. She had, let's see, on the original spreadsheet, Jane had a $400,000 Vanguard policy that ended in 889. So that's this one right here. Now, this one has become an inherited IRA. So I already went in and changed this one. So now John owns it. It's going to stay owned by John, and it's an inherited IRA. So all these other assets, I just have to go through here and make sure that they say now that where they used to say, for instance, they were owned by, well, they're just not even anything in them. So these are all owned by John's trust. So I just have to go through and do that, and I'll go ahead and do that, and then we'll have his spreadsheet all correct. So I'll go ahead and update the spreadsheet. And rename it. And here's the spreadsheet. And now this is just for John, post-death, after the death of Jane, and he's got an estate that's worth $7.3 million. And so we're going to go ahead and produce all new documents for him, will, power of attorney, advance directive, and then we're going to pretend that he's died, and we're going to go ahead and do a complete administration of his trust and show you how that works. Just to recap, we've already prepared the restated trust agreement for John, and it's on the screen right now. And you'll see that at the final distributions, there actually are, it calls for the creation of separate trusts for the two children, and they each have their own trust right here. Of course, Jane has already died, so there's no provision in it made for Jane. Now, I'd like to go forward and create new will, power of attorney, and advance directive for John at this point. So I go back to the estate plan, review or update, and we'll just go through this really quickly and produce the documents. So the documents that we're going to produce here are going to be we've already done the trust. We'll do the certification, the will, the power of attorney, and the advance directive. Let's just kind of read down through the questions and see if they're all answered. It's a pour over will. It's a restatement. This is the date of the original trust. This is the name of the trust. Got the information on the clients, the children, other important people, disinheritant. How about the personal representative? Let's see what we've got here. The personal representative, well, I think there's nothing here because we had Jane before. So it's going to be Robert and Sandra. So it'd be Robert would be primary, and then Sandra, the sister-in-law, and then we'll just delete this double entry here for Sandra. So that's going to be the personal representative, and the trust, let's see what we have here. The trust, we've already got all that in about Jane was one of the original settlors. The trustee designations ought to be correct because we've just, these are the original trustees, John and Jane. And then these are John will be the sole trustee on the restated trust, and then Robert and Sandra would follow. The trust tax ID information is going to be the social security number. The power of attorney, it's going to be this, will an attorney say no immediately? Attorneys, in fact, yeah, this had Jane originally, so now we have to do Robert and then Sandra. So this would be Robert, and then the alternate would be, the first successor would be Sandra, and then we're going to delete the second Sandra out of it. Okay, then we'll take a look at the, maybe I didn't I didn't see the advanced directive, or maybe I didn't check it. Let's see, go back up to documents. Oh yeah, I forgot to check advanced directive. There was no question. Let's go back now and answer the question on the advanced directive. Who's going to be the, so here we had Jane originally, so this would be, just a minute here, the advanced directive. Yeah, we would have Robert, then Sandra. That's correct. So we can go ahead and produce all the documents now. So that's how you would produce all the documents, and you just save them. So now at this point, we have updated John. We have a new spreadsheet for him. We've got his assets all figured out. We've got all his documents updated as a widower. And now we're gonna do another hypothetical, having John die, and then we'll go through a whole trust administration for him in the next video.